Okay, so today we'll talk about ESTA, obviously, that's why y'all came, so that should be no surprise, the amendments to it. Then we'll have a section where we'll talk about some of those considerations as managers and business owners that you need to consider when you're implementing a policy. There might be choices that you have that you are able to make that you don't even realize that might help make this easier for you to administer, so we'll talk about those. And then we'll also talk about some potential pitfalls to look out for, because it's very easy to step in it unintentionally. And so we'll highlight some of the things that I've seen over the past few months of other employers trying to comply. We'll get to learn possibly from some of their slip-ups and some of their experiences. So how did we get here, right? Are we having deja vu? Some of us were like, wait, didn't we already have this? Or what happened, right? Well, in 2018, this citizens group decided that they wanted to put forth a ballot. They had a proposal that they got enough signatures on, where they wanted to enact a law that provided paid time off to employees for sick purposes. The legislature was really nervous when they got enough signatures to get on the ballot, because this was truly a law that was drafted not by anybody who had employers at the mindset, right, at the front of their mind. This was totally employee friendly. There was no bipartisan nature in who drafted this ballot language. It purely came from this employee friendly lobbying group. And so when you read through it, you can see, I mean, as we're dealing with some of it, luckily some of it's been changed, but it was so employee friendly. It was really something that would disrupt business. It would be very difficult for employers to implement it the way it was written. And so when it got on the ballot, the legislature was like, oh no, we're nervous. What's gonna happen? What if it gets passed? And so they were trying to be creative and come up with a way to possibly avoid it. So they thought, well, look, clearly there's enough interest in having some type of law that would give employees paid leave for sick reasons. Let's adopt it, and then we can change it and make it work for us. So we take it out of the hands of the voters, we adopt it, and then we can amend it, because we're the state's Congress. So we're elected officials and we can change it, right? So that's what they did. And that's what several years ago we led to the Michigan Paid Medical Leave Act. So if you can recall from that time, they really cut up the ballot language. They made it only applicable to employers who had 50 or more employees. It was very restricted. It was only 40 hours. It was very restricted. And so that's what happened. And then, of course, that employee lobbying group sued. And they said, wait a second, this violates the Constitution. You took it out of the hands of the voters. The voters signed this thing, and they had the right to choose whether they wanted this. And the Supreme Court said, we agree. They said the issue that they found was that the legislature took it from the public, enacted the ballot language, and then changed it in the same legislative session. So it's really, this is just a procedural issue that backfired on them, because if they had waited until the next procedural legislative session to make the changes, it would have been fine. But they didn't. They adopted it and changed it immediately, and that's what the Supreme Court said was unlawful. And so what that meant is that Michigan employers were told that they had to comply with that original crazy employee-friendly ballot language as of February 21st. So that's what we were told. That, again, just put in mind that had not gone through any type of discussion. It hadn't gone through any type of debate where employers were like, these are our concerns, and none of that. It was just purely employee friendly. And there wasn't a lot of that legislative history for us to look at now and say, well, why was this language included? What does this mean? Normally the legislature talks, they have records where they say, well, it'll have transcripts of what they talk about, and so you can kind of glean what they were intending. We don't have that here. And so a lot of employers were scared. They were working really hard to try to comply. And at the 11th hour, literally at like midnight on the February 20th, they changed it. Now, there was a huge push to just wipe it out, make it just like PMLA. There was a huge push to all these other changes. They tied it in with this minimum wage act, if you recall, that also was talked about at the same time. So it made it very confusing for employers. We're like, what is actually on the table? What's being talked about? But they did make some changes, and those changes took immediate effect. So employers who were ready to go had to immediately comply. One of the big changes was that small employers with less than 11 employees, they don't have to comply until October 1st. So at least there was a little bit of leeway for them to catch their breath and figure out how are we going to do this. But those who had more than 10 employees, they had to comply immediately. And so just a quick note about the size, it's if you've had more than 10 employees in 20 calendar weeks for the current calendar year or the preceding calendar year, you are considered a large employer for that current calendar year. So if you have more than 10 employees, so even if it's like on average 10.5, whatever it is, if you have more than 10 for 20 calendar weeks in this calendar year or the last calendar year, and so it doesn't have to be the same employees for 20 calendar weeks, right? It could be that you had 19 employees here, 9 of those left, and you got new 9 employees or 3 employees, whatever it is. If you look at your payroll records and just run it by the week, the calendar week, and see how many employees were on your payroll, if you have more than 10 in 20 of those weeks, in either this year or last year, you are a large employer for the current year. And so let's say you're a large employer now, it falls off. Even if next year I have less than 10 employees, I'm still a large employer under ESTA because I had more than 10 employees for 20 calendar weeks last year. So there is like a lag where it's not going to be immediate if you drop down to, if you think, oh, I can avoid this by firing 2 people, right? No, you'll be covered for the year, right? And so you have to just consider that. So that's just the big note there. Yes, go ahead.
S corp owner, so more than 2% or more than 20% are they included as an employee?
So this is one of those gray areas where we don't know. It didn't describe it, but when you look at the FAQs on if you go to like Michigan LEO, it's their Labor Employment Opportunity, they have an FAQ fact sheet that you can click, and it kind of tells you what is employee. If you pay, even if they're an S corp owner, if they get a W-2 wage, they're an employee under this act, right? If you treat them as an employee, if they get wages that are subject to employment taxes, they're considered an employee under this. Now, there's difference with like elected officials and things like that, but if they get a W-2 wage, they essentially are an employee. And so that's at least for now what we know.
It is employee count, not FTE, correct?
That's right. It is employee count, not number of hours, not, so any employee, and this is another, it covers all employees. So temporary employees, seasonal employees, you've got to count them. That's why you break it down by week and look at how many employees were on your payroll for each week. That's how you'll know. And then you got to be careful because a lot of smaller employers, I mean large employers do this too, but what I see is a lot of smaller employers will have improperly classified workers as independent contractors. And under this statute, they look at the same facts, at least this is how the LEO is interpreting it. They'll look at the same facts as what is legal definition of employment. And if they think that you've misclassified someone as an independent contractor, they are an employee under this statute, and you might have to give them paid time off too. So that just might encourage y'all to look at, do we have independent contractors, and how sure are we that they truly are independent contractors? Because you would hate for it to come back to bite you in the butt later if you end that relationship and now they say, oh, well, this is retaliation for ESTA, right? Whatever it could be. And in fact, that could be the issue for a lot of different statutes. So you should always check if your independent contractors are properly classified. The change, just so y'all know, that they added here is that it now excludes minors from the count. Under ESTA, employees who can make their own, actually not the count, it includes them as employees, excludes them as employees, but who can make up their own hours without minimum requirements. That the LEO has really restricted that. A lot of people were like, oh great, especially for like gig economy workers, you're like, they can just work whenever they want, I don't care, they don't get ESTA, right? No, they've limited that on the FAQs. We'll see if the courts agree with that. And then unpaid interns or trainees. Now, if you're a for-profit business, you're not allowed to have unpaid interns. So just making that clear, hopefully you don't have that. We'll have issues. But anywho, but basically every employee counts in terms of coverage, whether you're small or large employer. And then what it initially told us is 72 hours of paid leave each year. If you're a small business, it's up to 40, right? So that stays the same. If you have less than 10 and under, then you only have to give 40 hours of paid time. If you have more than that, it's 72 hours. The accrual, they can accrue 1 hour for every 30 hours worked. That's the rate. Or they allow you to front load, and you have to front load the entire amount. If they're a current employee, you have to front load the entire amount, so that could be the 72 or the 40, depending on your size. They allow you to prorate if it's a new employee who's hired within the, so let's say you pick a January 1st calendar year for your benefit year. You hire someone in June, right? You are allowed to prorate. You don't have to give them the full 72 hours if that's your year. You have to prorate it based on what you expect, like the number of hours you expect them to work and all of that. And they require you to give a written statement to them explaining that. And then at the end of the year, you just have to double check, like, did they work a crap ton of overtime, or something that changed their expectations and they would have been entitled to more, then you have to give that. But you are allowed to prorate if you're using front loading, so that you don't get stuck where someone comes to starts work on December, right? In December, and they get a full 72 or something right away for that month. We'll talk about accrual and front loading, some of the differences between the two. And then caps. So before, there was no cap on accrual. So if they worked 1 million hours, right, they can accrue all of the time under ESTA, 1 hour for every 30 hours worked, but you can cap the usage and the carryover. This is one of those things that's so dumb. Because it's like, why do this? If they can't use it and if they can't carry it over, why do I have to track it? Why does it have to be in their bank? Because then the employees get mad thinking, I have all this time and I'm not allowed to use it, and it really makes them angry. But that is what it is. You have to, if you are accruing, right, if you are using the accrual method, just be careful about your language and your policy. There's no cap on accrual. They could accrue until a cow comes home if they work a lot of hours. What you are allowed to cap is usage during that year. So you can cap that at 72 or the 40, and you can cap carryover at 72 or 40. So essentially they could accrue and then they'll just never be able to use it. It's a weird, dumb issue with the law. And it technically, if you're not keeping track of records showing that you're doing that endless accrual, then you're violating ESTA. So ESTA is essentially, it's just to give them time off for specific reasons, right? You technically don't have to let them use this for vacation or whatever else, right? It's under the law, you only have to give it to them for these reasons. They are relatively broad because people can say, well, what's mental health like? Like for instance, taking care of an employee or family member, diagnosis, care, treatment, right? If my kid needs to go to the doctor, that's covered, obviously. What if I say this is a mental health treatment for my child is to go to Disney World? Right? So and that's what we're dealing with, right? And we don't have any guidance yet on how these are interpreted, and so it's just, keep that in mind, right? But this is what it's supposed to be, and we can make it clear in your policies that being dishonest and untruthful in your request for ESTA is something we can take action for. So at least you could put it in there if someone's like, oh, we're sick, and then you see them that they're playing softball, in a weekend tournament or something, we could hold them accountable. But this is what it is. Preventative care, closure of work, school due to public order. A lot of people are like, is this what we've been experiencing, or questions on is, what if school's closed for snow, right? Does that count? No, technically it's not a public order from health. It's not about communicable disease. It's just a school district's decision to close. So it technically doesn't cover. Sometimes though, employers right now, you'll see when we talk about some of the abuse, the way that this can be abused, they're like, just use it. I'll let you use it, and once it's exhausted, then I can hold you accountable to it. Because otherwise I'm stepping into it. If I'm like questioning always and asking what you're doing, it's like you might as well just let them use it and then we move on. But these are the reasons. The waiting period, it started out at 90 days. They've upped this to help especially those who have seasonal workers. If you are accruing time, so this is one of the reasons why some people are choosing, if they rely a lot on heavily seasonal workers, they're choosing accrual for those workers because they have to wait 120 days, or you can have a 120-day waiting period before they can actually use any of the accrued time. So if they are working for less than 120 days, you say, okay, you accrue it, you have to have records that they're accruing it, but they'll never be able to use it because their employment will end.
Can you have a combination of both?
You can. So you can make it, but this is where it becomes an issue. It's harder sometimes for payroll companies or whatever to have multiple different banks tracking different ways, but you can, as employers can set up like, this is our benefit for full-time employees. We allow you to use it for whatever, vacation or ESTA. This is our benefit for all other employees, it's just ESTA only. Or full-time employees get it front-loaded and all other employees have to accrue it, right? Like you can set that up. You just have to make sure that we clarify that in your policy and that whoever you're using to, whether you're doing it in QuickBooks or whatever you're tracking time off, that they're doing it appropriately. Okay, but so that's a benefit of the accruing time, is that you can impose a 120-day waiting period. If it's front loading, there's no waiting period. They're allowed to use it immediately. And so that some people are getting caught up on that because it then gives them a full bank to just abuse. But employers are like, look, in the end, I'm gonna let you use it for whatever anyways, might as well use it. And then once that's done, I can move on to holding you accountable. So it's kind of, what's the best method for you? What's the best of both evils, right? You just pick one that works. Family members was another thing. This one is, it's very broad, right? It's all of these, the normal family members that you're probably used to in terms of like FMLA or things like that. But here's the big one. It added this: individuals related by blood or whose close association with employee is equivalent to family. And there's no way to test that, to challenge it. So people, like, it could be like, my neighbor is, or my best friend is like a sister to me, and she needs me to be with her at her doctor's appointment, right? And maybe that's true. Maybe she's going in for diagnosis for breast cancer or something. You want to support your best friend. They could technically say that this is their equivalent to family, and there's no way for us to challenge it. Like, what are you going to do? Prove it, right? There's no way. So I'm just be clear. That's why a lot of employers are like, at this point, our hands are tied. Might as well just let them use the darn time, and then we move on. So just so you're aware there. Notice period. This is what John was talking about. If you're going to allow them for PTO as well, you can say, hey, if it's for a non-ESTA reason, we want 2 weeks notice in advance, whatever, if it's non-ESTA. And we reserve the right to deny requests, like we can, because scheduling or whatever. But if it's for ESTA, we can't deny the request. So we can't consider whether 12 other people are out and you're asking to go out too for ESTA. I have to grant it if it's an ESTA reason and if you have ESTA time. This is the only notice requirements for ESTA. If it's foreseeable, you cannot require more than 7 days notice, which is crazy. If someone knows they have to go out for surgery, they know 3 months in advance, we can't ask them to tell us except for a week before, right? So, but that's it. You can't, if it's for ESTA, you can't require them. They could tell you, that's fine, but you can't require them to tell you. If it's not foreseeable, they have to tell you as soon as practicable. They did make this change, but I don't think it's helpful. In this, the overnight last minute, change, they said, oh, you can require them to follow your normal notification procedures if possible. So what that means is, like, if I didn't know that like, let's say you say I have to call you between an hour before my shift to call out for it to be excused. I can say, you have to do that if you knew that you needed the ESTA before the hour. What if someone's like, oh, I thought I was fine until 5 minutes before work, now I'm sick, I don't have to comply. And there's no way for us as an employer to challenge that. So it's truly only if it's a real, like if we truly know, there's like, you're telling us you had to go to a doctor's appointment, you're telling me this 5 minutes before your shift, that you clearly knew before. So that technically could be denied, right? But in the end, it's really hard for us because there's no way for us to challenge if someone truly knew or didn't know in a lot of these instances. So just keep that in mind. Your policy should be updated to say, like, your attendance call-in procedures should be updated, and it should say things in there too about if it's for ESTA reasons, comply with our ESTA policy. And the ESTA policy says, if it's this, it says if it's foreseeable 7 days, if not, as soon as practicable, but comply with our regular call-in procedure if possible. Documentation, this is the one that gives a lot of people headaches. We're not even allowed to ask for any documentation to substantiate time. You cannot even ask for it until they've been gone for more than 3 consecutive days. And if you do ask for it, we have to pay for every out-of-pocket cost from the physician or whatever that's charged to the employee to produce the documentation. So if you are a small business and you don't provide health insurance coverage, they could be paying out of pocket to go to the doctor, right, if they don't have health insurance. And you then would be on the hook for covering that cost. If you have insurance and there's a copay or something else, then you'd have to be on the hook of covering that cost. So you want to be careful to look at your policies, and maybe some people used to say, like, yes, you're required, if you're absent more than a day or whatever, you're required to have a doctor's note, you want to walk that back because under ESTA you can't ask unless it's been 3 consecutive days and you have to pay for it. So you may not want, you might just want to say we reserve the right to request documentation, so you can decide. Okay, you're allowed to use in 1 hour of time or the smallest increment of time you can choose as an employer. So if that was a change, it used to be just the smallest increment of time that you were tracking for timekeeping. Now you can say 1 hour. Payout, you're not required to pay out any unused ESTA. This is a big one. A lot of people thought I have to pay it out. Nope, if they don't use it, they lose it, right? You don't have to pay it out. If they're terminated or if they leave, you don't have to pay it out. You just want to be sure that your policy is clear. It allows payout. If you don't want, let's say you're doing accrual and you don't want to have to carry over accrued amounts, you can pay them out. It allows you to pay them out and then let them start accruing again. It allows you to have that flexibility, but that's if you just don't want them to take the time and you want to pay it out instead of having it in their bank. You're allowed to do that to avoid carryover, but you have to pay it out if you do that. Otherwise, you don't have to pay it out, so you got to be really clear about that in your policy. If you're not clear, they can make the argument that they're entitled to it, so you need to be clear in your policy. Reinstatement, this is what we talked about. If they are rehired within 2 months of their separation, you have to reinstate any of that unused time. So just because they've been termed, you still keep it on your books that there's some time there until we hit that 2-month period, because then you can wipe that out. If they're hired within the 2 months, you have to reload it to their account, and there's no new waiting period to use. So there was a lot of people were scared. I was scared. There was this presumption of retaliation in the initial act. It got changed. However, I want to just remind you that we are prevented from retaliating against employees for taking ESTA as allowed. So you want to be really careful about managers, and it happens all the time, it's just normal. Managers being like, God, Lindsay's been out 5 times this month or something, right? Talking about it. And if it's ESTA, you can't say that. That looks like you're chilling other people using ESTA. It looks like you're treating me differently because I used ESTA, right? So you got to be very careful. You can't use that missed time as a basis for performance evaluation issues. You want to stay away from saying Lindsay has attendance issues. If we look at my thing and it's just me taking ESTA, that's a problem, right? That's retaliating for me using ESTA. So you got to be really careful. That's why when we're talking about you can hold people accountable for not complying with your notice procedures, you still want to be very careful because it's intertwined with ESTA automatically. They're using ESTA, they didn't comply with notice. The plaintiff's attorney could say it's because of ESTA. And if you've treated me harsher than any other employee who hasn't used ESTA for the attendance, then that looks like it's ESTA. So you got to be really careful. So it's there, they removed it, but I still think we have the issue. Employers need to be very careful about not retaliating. We have some management considerations we've talked about. Do you want it in a separate bank, EST, like earned sick time, versus putting it all in one bank, PTO, and allowing them to use it as is? Some employers who are already giving paid time off really like just leaving it as one bank because they're like, we just need to make sure that it's clear in your policies. It's one bank. For those of you who have it, we are letting you use it for whatever purpose. And then some are saying it's all PTO. I don't want my staff feeling like, oh, even part-time don't get PTO. We just say in the policy, PTO for part-time can only be used for ESTA reasons. And they just all call it paid time off, right? But you have to be very clear about who can use stuff. So there's positives to having it be EST versus PTO because you clearly know if they use it out of this bank, it cannot be it can't be touched. It can't be considered as it can't be considered as an attendance issue. I can't deny it. I'm not going to flub over the issues I've asked. I just know if it's EST, it's boom, one and done, gone. And then PTO, I can apply all of my normal procedures. I can say I want a month's notice if I want, right? Before, and I don't have to grant you unexpected or unplanned PTO, right? So there's some employers are choosing to have 2 separate. Others are saying it makes more sense to just have it all in one bank. I don't want to have to keep track of a million different things. If you're going to do the PTO in one bank, if it is over 7, if you're already giving them 160 hours, the issue there is you just have to be very clear that once they've used 72 hours of PTO for ESTA reasons, your normal PTO notice requirements apply. Because that's the issue. With PTO, all in one bank, you still have to track whether that PTO is being used for ESTA reason or non-ESTA reason. So it's kind of like a bank within a bank. So are you really saving yourself time? And then, so these are some of the same, I mean, we've talked about a lot of them, but the accrual versus front load, we've talked about the pros and cons of each. Payout versus payout, or no payout. Obviously, you're not required to pay out. If you pay out upon separation, you don't have to reinstate that time if they come back. So if you are someone who has people coming back within 2 months, you know, you could think about that. But if you pay it out, then they start over as a new employee. And if you're front loading, they could get a new 40 hours after you've just paid them out 40 hours, right? So think about that. Be clear in your policy. I'm sorry, am I going over? And then the ESTA notice for large employers was supposed to be given March 21st. You're supposed to comply by February 28th, so that notice was not helpful. They're like, oh, you can have a month to tell your employees about it, but you have to start complying immediately. For small employers, just be sure you have your notice ready. It's 10/1, October 1st is when small employers have to comply. So make sure you have that. You are required to post the ESTA poster as well with all of your other labor law posters and employment law posters. So be sure you do that. The poster has language about how they can complain if they feel like something's been violated. It tells them how to contact the LEO. Technically, if you're having a policy, your policy should say that too. I hate that. I don't like to put that in my policies. So at least for the notice requirement, what I do is I've told my clients, give them a copy of the notice that the state is passing out and say, this is in our break room, here it is. And then the policy can just say what it says. We don't have to say, you can contact the Michigan Department of, whatever, if you feel like you've been, but it still says we prevent retaliation. And then you have the please report to HR or whatever if you feel like you're being retaliated. But the issue is you want to be sure you have documentation that your employees have received the notice, the poster, and your policy. And so for me, it's on their hire date, you give them a copy of the notice, you give them the handbook acknowledgement says in there, like, I've read it, and then it also says, I've read the handbook policy related to Earned Sick Time Act and have received it. So just so we have that for their personnel file and you've at least met that requirement. Potential pitfalls, we've talked about the attendance issues. Intermittent leave, this is a big one where I'm just seeing it in a lot of workplaces, they're using it to change their schedules. That's why if you give a ton of time, people could just be using it every Friday at 2 to leave early. And you start to see. Now, yep, and they just start saying it's because they're sick, and there's no way, because they're not using it more than 3 consecutive days in a row, I can't ask for questions, I can't ask for documentation. If it's like that obvious, we could ask questions, but again, where does that get us? We're not allowed to ask for documentation. So if that employee tells you till they're blue in the face that it's because they're sick every Friday, then we might have to allow it. However, that might trigger then accommodation discussions that we'd have to talk about, and you could possibly get a doctor's note under accommodation request, and that might deter someone from abusing this. But anyways, intermittent leave is an issue, so be sure that you're consistently applying your notice procedures, like we've said, not just against those who are using ESTA. You need to apply it with everybody. If you're gonna draw a hard line at like 30 minutes before your shift, you have to call, or it's unexcused, you have to do that with everybody, not just those who are using it for ESTA. And I've said careful about mandatory charges. So again, if you can't just force their charge. If it's all in one bank and they can use it for whatever, and you're counting that time as ESTA time, I cannot force you to use it for a non-ESTA reason. You guys get that? So I can't just charge it because you're late an hour. Even if you don't say it's ESTA, I can't, if you say I was just late, I can't charge that time. I just have to tell you it's unpaid unless you ask me to charge it. And I can still say it's a violation, unexcused, whatever, I can hold you accountable. But I cannot mandatorily charge that and reduce it down. If you have 160 hours, you could. You could charge every absence until you get to the point where I'm not interfering with your ability to use 72 hours. So you just gotta be careful. No retaliation, we've already said that. Update your attendance policies. A lot of policies will have points assigned to any absence. You can't do that if the absence is a protected absence. You cannot assign a point to it. So make sure you have updated those. Proper performance management practices, that's just to make sure if you are documenting performance issues as they arise, if you're addressing misconduct as it arises, and you have a practice of doing that, that really helps you prove that if I'm ultimately terminating Lindsay, here's all the documentation of all the issues that I've talked with Lindsay. It's not just because Lindsay took ESTA yesterday, the day before I termed her, right? That helps you disprove the retaliation. If you're like, Lindsay's been a poor performer, that's why I fired her, and my lawyer, my plaintiff's lawyer will be like, did you take ESTA time in the past 2 months? And if I'm like, yeah, I did, I took a week. They could be like, okay, that's why you fired her. If there was no write-up, if my performance evaluations look great and I have no performance issues, then we're having to prove a negative. Like, how are we supposed to prove that it wasn't the ESTA time that made Lindsay be terminated, right? So I'm just encouraging you to be sure you have consistent performance management practices throughout the year, that you document things so that we can point to that if we need to say it wasn't retaliation. Because this is the other thing you will see. Employees know that something's coming down the pipeline. They know that, oh, my manager made a meeting. I'm going to call and say I'm sick this morning. I'm going to come in an hour late. I've used ESTA time, and you terminate me right after it. It looks like it's because of ESTA, right? So that's what you're going to have to deal with. And then careful with documentation requests. Managers might think, just like in the past, I can just say, give me a note for that. Give me a doctor's note for that. You were out. You don't want to do that because we could run into issues with the ESTA rules. And again, this is that one I told you about, like, be careful who has access to the time off request forms. If someone has to detail that they're requesting ESTA because my mom's sick, everybody in the company shouldn't see my time off request, right? The use of ESTA time is supposed to be confidential. This is the big one. Remember that medical and domestic violence, sexual assault information must be kept confidential. Do not share reasons for someone being out with coworkers. It feels very just part of your nature, right? To be like, oh, Lindsay's husband's sick or something, right? Let's all go together. Let's give a meal train, whatever. If I haven't told you that it's okay to share that, you're sharing confidential medical information, and that could be a problem. It violates this law as well as ADA and a bunch of other things. So be careful. And that's the other thing too. If it's like, well, y'all are having to cover Lindsay's shift again. She's out on ESTA. Right? No, like now people know I have a medical issue or what, right? You have to be very careful not to talk about, and you might want to justify, coworkers might be really pissed that Lindsay's been off for 5 days. But I may want to say, no, it's because she has a real issue, like don't be mad at her. No, I cannot share that unless the employee tells me to. So just check yourself. It's very easy to fall into that trap because we're trying to care for our employees. So that's it.